Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies. Welcome to Navigating Receiverships. I'm here today with Steve Donell, president of FedReceiver, and one of the receivers out of California that has had some fascinating cases over his career. So thanks so much for joining us. Can you tell us a little bit about your background and experience?
Thanks, Eric. Yes, hi, I'm president of FedReceiver, Inc. I'm also president of Jalmar Properties, and I got my start in receiverships close to 30 years ago. Between receiverships, partitions, and provisional directorships, I've handled about 900 cases in state and federal court. Past president of NAFER, past president of the California Receivers Forum, and really got into receiverships many years ago because of our experience in property management. We manage commercial and residential properties, and we were introduced to a lawyer who represented a bank, and the bank was looking for a receiver that understood how to manage real estate. And we asked to get our first case in the early 90s, and we got that first case, and that changed the trajectory of our careers. And as I say, that was about 900 cases ago, and that then morphed into the real estate cases, morphed into federal equity receiverships involving the Securities and Exchange Commission, Federal Trade Commission, partnership disputes, and on and on. So it really started through our experience in commercial and residential real estate management.
And you've really expanded well beyond that, though, right? You're not just focused on residential and real estate management anymore in these receiverships, and especially in these federal equity receiverships that you're working in. We're going to talk a little bit today about just distributorship that you took through receivership. Tell us a little bit about what was going on in the industry or what problems might have existed with that company.
Well, so we've had many cases involving a variety of different types of disputes. There was one particular case, this goes back 7-8 years ago, a very interesting case involving a company that distributed generators. And that company borrowed many millions of dollars from a commercial lender. And the lender didn't really keep track of the receivables and the inventory. One thing led to another, and it turns out that the company had engaged in fraud. And I was appointed in state court in California to take possession of the company and all of the inventory. And that then led to a multi-state series of actions where I started in California. I then followed the paper trail, and that led me to Ohio. I landed in Ohio, found the warehouse where there had been millions of dollars of inventory stored, and found out that they had relocated it. So I brought in local counsel in Ohio. We filed a no notice ex parte seeking to effectuate jurisdiction, a sister state jurisdiction from the California order to Ohio. I got that order. I then found that they had moved the inventory down into Indiana. I hired local counsel in Indiana the next day. We got a no notice ex parte order with a recognition order in Indiana. I went to the warehouse in Indiana, found out 2 days prior to that they had moved the inventory up to Illinois. I then retained local counsel in Illinois. We got a no notice ex parte order recognizing my initial order from California and Ohio and Indiana up in Illinois. I finally was able to track down inventory there. We then found out that there was inventory in Wisconsin. I got a no notice ex parte order in Wisconsin. And then the money trail led us to Toronto. And I ultimately got, again, very similar procedures in Canada with respect to the operations of receiverships. I was able to get a no notice ex parte order appointing me as receiver in all provinces in Canada through the Court of Queen's Bench. And I still remember that to this day. and I was able to hire local counsel in Canada, hired an auctioneer, and we recovered millions of dollars of inventory up in Canada, as well as those other jurisdictions. So it was a tangled mess of deceit, a web of deceit. Ultimately, the criminal investigators got involved at the federal level, and one of the principals fled to China, and another principal ended up getting sentenced in a criminal action and served many years in prison. So that was an interesting case involving literally finding the money trail, finding the inventory, ultimately sold millions of dollars of inventory, and did provide a return to the secured creditor lender.
So let's jump back a little bit. You started out with this, jumping from state to state and having to kind of dig up the inventory or go in search of that inventory. Did you ever consider, going and filing in federal court as opposed to just going to each state, or how did that play out? Because obviously every state's a little bit different on how they view these actions of, I mean, even to the courts that you file them in, obviously you did the right thing, you retained local counsel in each of those places. What were kind of some of the thoughts that were going through your head as you were, we missed them again?
Yeah, well, there's obviously the issue of diversity and the requirement for diversity in federal court. And we did discuss that. Discussed it with lenders counsel and discussed it with my initial counsel in the Midwest. And that firm fortunately had multiple offices in the Midwest. Because this was such a time-sensitive issue, and we were literally a couple of days behind the borrowers that were relocating this inventory, and by the way, selling some of it along the way, that we decided that the time involved in trying to file a new lawsuit in federal court and hopefully getting an order from the federal court, that it would just take too much time. So we decided to take our chances in state court, and it worked the first time, and then it worked the second time, the third time, the fourth time, and ultimately, again, worked even up in Canada, where we kept it in the state court system. So while we did discuss it, given the extreme time urgency and our success with bringing in local counsel, we opted to keep it in state court.
And so then you touched on it there, but you then had to file in Canada. How was that interaction between the two countries? Like, I mean, was it seamless? Was it, you're not even talking same currency, right? I mean, at least if you say $1 in Ohio and $1 in California, they might buy you different amounts of goods in Ohio versus California, but you at least are speaking the same currency. What did that process play out and look like for you?
Well, fortunately, the underlying scheme that Canada has with respect to the appointment of receiver, the operation of a receiver, this goes back to Old English law back in England, initially. And so there's a lot of similarities, and it was fascinating because the appointing judge in California was bouncing off of orders in Canada, and the Canadian court was waiting for orders in the initial California court, and they were reviewing each other's orders and were relying upon each respective court's orders. And so we found that there was a great deal of cooperation. We ended up getting the Rocky Mounted Police involved, which is their equivalent of their, the FBI there. I was able to hire an auctioneer. We did have some conversion issues with currency. We also had to deal with taxes in Canada. So I had to hire a CPA in Canada, as well as local counsel, and make sure that all of the tax issues in Canada were straightened out before I was able to distribute the funds. So I had a multi-jurisdictional issue regarding taxes, both in the United States, multiple states, as well as Canada. But by and large, it worked out pretty well. And fortunately, there are a lot of corollaries between the laws and how they're employed both at the state level in the United States and in Canada.
It's nice when it comes together smoothly, right? Because those are things out of your control as the receiver, but it's good when it does work out. So you filed in all of these, you've touched on that you went through a liquidation through an auctioneer and everything. What are some of the actions in this case that really made this stand out to you and made it different to you?
Well, I think one of the things that stood out, and I remember this very distinctly, in Indiana, the industrial building was located in a tertiary area in a relatively small town, not too far out of a larger city, but the courthouse was a very, very small courthouse. And so I brought in some fairly large law firm out of the Midwest, and they said, you know what? This local courthouse is so local, although we're not as huge as some of the Los Angeles or New York or Chicago firms, we actually think that we need to employ local counsel.
Yep.
And I attended the hearing, and sure enough, we had local counsel who knew the judge personally, and it made all the difference in the world. And that was really what broke open this case was our order in Indiana, which then led to the paper trail. So I think following my attorney's advice, bringing in local counsel, and the ability to work with speed, the ability for the lenders council in California to fund some of the operations, and then also for me to bring in a forensic accounting firm who was feeding me information and intel in real time as I'm in one hotel after another and getting on planes. So it was literally putting out one spot fire after another. So I think speed, the cooperation of local counsel, and the judges in the different jurisdictions understanding the issue of speed and the dissipation of assets. We had ample evidence that the borrowers were selling some of the inventory along the way at depressed prices. And so I think that the speed, the use of counsel, the use of CPAs, and the fact that we got lucky with judges that understood the issues, that made all the difference in this very complex case.
Yeah, and so you touched on some of the outcomes that kind of came out of all those complexities. You mentioned that you were able to recover funds, obviously, that were used to pay back the secured creditors. You mentioned that there was perhaps some jail time that went for some of these. I'm assuming that this was completely a liquidation and wind down of the entity. You can correct me if I'm wrong there, but was there anything else that kind of came out of this process that was maybe a surprising outcome when you first got started?
Well, I think one of the surprises was just the level of deceit that the borrowers had engaged in. And, I've had a lot of cases and I'm used to defendants and borrowers not being forthright, but just the level of deceit that they had engaged in. The case not only involved mortgage fraud, but it also involved federal and state taxing agencies. They had not been reporting their sales. So there were multiple levels of both civil and criminal enforcement involving mortgage fraud, activities across state lines, and then both state and federal taxing agencies. We were dealing with taxing agencies at the state level in 5 different states, plus Canada. And so my forensic accountants had quite a tall order. I was not able to distribute the funds to the secured creditors until we got tax clearance from the IRS, from the Canadian government, as well as the various state taxing agencies. And that process took about 4 to 6 months. And initially the lender was frustrated. So I had to educate the lender about why it was taking so long to allow me to distribute funds. Because as we know, if receivers distribute funds to creditors without giving the taxing agencies an opportunity to submit a claim, there's ample case law out there that receivers can have personal liability. And so the lender, as well as I think lenders counsel, was really educated about that process. And although it took longer than we had hoped initially, not knowing the complexity, I think everybody was satisfied at the end, notwithstanding the fact that it did take some time. So the tax issues and the criminality were not something that I had initially anticipated, but it ended up in a relatively good result.
Yeah, I think it's really important for everyone to understand if the IRS is happy, you're going to be in a better situation as a receiver,
Exactly.
because there are certain people you can push back on. The IRS is probably not one of them.
Agreed.
And to a lesser extent, state tax agencies, but IRS always first and foremost. So you've gone through all this. As you look back now and work on new cases, what are some of the lessons learned that you really probably implement more regularly?
Well, one of the things that's so important, especially in the federal equity cases, is for receivers to remember that they must record the order in the jurisdiction where assets are located within that 10-day period. Although this was a state court case, we worked very diligently to get my orders recorded quickly. And so the issue of effectuating jurisdiction and doing so very, very quickly is extraordinarily important, number one. Number two, being on top of the tax issues, as I've mentioned, is very, very important. I also think in this case, more so than in most of the cases I've handled, hundreds of cases, is the importance of keeping the parties informed. And primarily in this case, it was lenders counsel, because this thing turned into a monster. Nobody understood initially that this small, relatively small, simple case originating out of the greater, well, it was San Bernardino County, east of Los Angeles, would have tentacles that would lead to 4 other states plus Canada. And so we worked very, very hard to keep lenders counsel informed and involved. And I think the reality was setting in with lenders counsel just how complex and expensive this case was going to be. So avoiding surprises is really important for receivers. You don't want the litigants, the creditors to be surprised. So we worked very, very hard to keep lenders counsel apprised of our progress, the difficulties we were encountering, and why we needed to continue to retain local counsel. And at the end of the day, the efforts bore fruit. And although the lender took a loss, I think that they felt that we recovered as much as we reasonably could under the circumstances.
When you think through this, then you've obviously, depending on who you ask, it was a successful outcome, right? Sometimes the banks don't always feel that way, or the lenders don't always feel that way because they always wanted more, but you've taken this as a successful outcome. What should someone else that was kind of watching it from the outside, whether that was that lenders counsel or whether it's the judge or anyone else, what should others take away from a case like this?
I think one of the takeaways is just how quickly a borrower can get away from a lender when the inventory and accounts receivables for that type of C&I loan are not being vetted and analyzed and followed. This particular borrower was creating false inventory schedules and was creating false accounts receivables schedules. And in fact, what they were doing is they were selling the inventory on the side, pocketing the money, and then they were fraudulently transferring the funds overseas. And they were trying to keep up the charade as long as possible. And this had been going on for about 24 months. So I think one of the lessons here for the lender was that they needed to go in and perform a physical eyes-on inspection, because the inventory was very different than what was being provided on a quarterly basis to the bank. And then I think the other takeaway here is the issue of criminality, not only negligence, but the criminality that the borrowers had engaged in. And I would also say that the borrowers' attorneys probably aided and abetted their activities. And I had at one point considered suing the lawyers for the borrowers on behalf of the estate. We ultimately performed a cost-benefit analysis and decided not to do so. But in this instance, the lawyers involved were not exactly being forthright and transparent. Notwithstanding the attorney-client privilege, the information that had been disseminated was just blatantly false. And so I think that they had crossed the line a little bit too with respect to advocacy versus complicity.
Mm-hmm. Yeah, I think you look through something like this and you look at intent, right? And that clearly in your case here, there was intent to deceive. Sometimes you come into these cases and you go, this isn't really intent as much as it's lack of intelligence or, lack of paying attention or whatever it might be. And when that intent does come in, then you do have to look at everything. And I think you touched on something really, really smart there when you were talking about deciding whether to sue the lawyers in the estate. And I think it's one of those things that as a receiver, you have to do that cost benefit analysis that you touched on and make a decision as to whether there is going to be a valuable return on investment. And if those numbers are close to what those costs might be, you probably as the receiver have to say, this probably isn't in our best interest right now because it's going to drag this out. There's guaranteed costs, there's not guaranteed returns.
That's right.
And so I've actually, in some of my cases, and I don't know if you consider doing this as well, when I've had banks or lenders really aggressively wanting to pursue those charges with, maybe it was a law firm or someone else, I've offered to assign them the rights to the case, but I just told them, look, I can't see the value of the outcome here. I know this is going to just run up costs, and I understand you're the secured creditor, but I think at this point it's not in the best interest of the receivership. And so I don't know if you, I know you had some educational pieces with the lender in this case. I don't know if you had to go through anything like that with him as well.
Yeah, well, actually, there were some additional pieces of inventory in another location. And because they were so de minimis, I did make the judgment call that we were not going to pursue those. And we got court approval to abandon those assets. And so yeah, it's definitely a judgment call. And receivers need to use their reasonable business judgment to decide, how far they're going to push and attempt recovery. And having said that, I actually am in litigation against 3 lawyers right now today in 3 other cases where I did opt to sue lawyers in equity receiverships I have. So every case is very, very different, and you really do need to perform that cost benefit analysis.
Yeah, this is great information for people listening in. I'm not sure if there's anything you'd like to leave people with before we go, but this has been really informative, and I think a really fascinating story to how this all played out, and really why navigating receiverships came to be, is we want to hear these amazing stories that our community has.
Well, if there's one message, for those that are experienced receivers, this is not going to be illuminating. But for those that are just getting into the receivership world, I would say this: many, many receiverships are just like the tip of the iceberg. And it's what's below the waterline that oftentimes is the meat of the case. And in order to properly staff a complex equity receivership involving a business, the receiver needs to act with speed, needs to come in with a good team, including in-house folks, receiver administrators, accounting, bringing in third-party forensic accountants, attorneys, auctioneers, folks that can properly value assets, to work with speed, to be able to have boots on the ground in different jurisdictions, because it's what's below that waterline, the 90% that you can't see, that's where the receiver and the receiver's team can make the difference. And be prepared to be surprised, and be prepared for information, facts, and evidence that even the creditors and creditors' counsel are not aware of. That's why the receivers get appointed by the court, to uncover the mess and to create order out of chaos. So it's about staffing, it's about speed, it's about efficiency, and it's about competency. And if those ingredients are present with the receiver's team, fantastic results can be achieved. But if those ingredients are not present, and it's a new receiver team facing a very complex case, the outcome may not always be so favorable.
That's great advice. I think whether it's for receiverships or just in general, a lot of those are qualities that are required to make up a successful business of any sort, because business does move quickly, and if you're not moving quickly with it and with a qualified team, then you're probably going to fall behind in a lot of suits, and maybe end up with your own business in receivership.
There you go.
But
Hopefully not.
thank you so much, Steve. This has been great. I really appreciate you taking the time today. We'll look forward to hearing more of your stories in the future.
Eric, thank you very much. I really appreciate it.
Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org, and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.